person accused, do you get a chance to speak directly, or do you do all the talking for your client?
Yeah, but there's a reason why you have a solicitor, and they're there to speak for you. You shouldn't talk. In most cases, people don't want to talk. Actually, one of the things they'll ask me is, do I have to talk? And I'll tell them, no, you don't. If you're represented by a solicitor or by a lawyer, you don't have to say anything. The judge will speak to your lawyer. Your only job as a person before the court, before the trial date, if there is a trial date, is just to be there. And so the judge can see that you're there. But you're not required to say anything or to enter any plea on the first day, or even on the first day you don't enter any plea, you don't say anything. But when you're represented, your lawyer does all the talking for you. Everyone who's charged with drink driving or drug driving, everyone who comes to court is over the limit. They all are. But about 2/3 of them are convicted, and about 1/3 are not. So that means that 1/3 were acquitted, even though every single one of them were over the limit. So just because you're over the limit doesn't mean that your case is hopeless. It isn't. Sometimes procedural errors happen, sometimes they don't. The guards do a lot of work on drink driving. They prepare very well for it. It's taught at a very early stage in Templemore. I remember my time up there, it was a heavy emphasis given to it. But you have to go through it to see has there errors been made, and if there is, then you may have a good defence. Yeah, oftentimes, I mean, I'll talk to people initially at the first stage, and then I'll ask them to write out in fairly good detail what happened in the form of an email, and to do it straight away. The longer you leave something, the more likelihood is that you'll forget bits and pieces. So I ask people to kind of focus on what happened, to focus on what time of the day it was, where they were going to, where they were coming from, what did the guard say to them, and so on. So as much detail as possible, and to write it out quickly before you before you forget it. And that is your account going forward. So the sooner you get started on that, the better. That's actually one of the best things you can do for yourself straight away.
If somebody contacts you who's been charged with drink driving or drug driving, talk us through the process. What happens between you and that person?
Well, first of all, I ask them, have they been charged or not? If they have been charged, then there's a date coming up quite soon, in the next 30 days, where we're going to have to get someone into court and to get the case adjourned. Every case that comes into court is adjourned for about 6 weeks to 8 weeks. 6 or 8 weeks, because every drink driving and drug driving case involves a number of guards, statements take a while to put together, documentary evidence, all that kind of stuff, and that won't be delivered on the first day in court. It'll take a couple of weeks. So when you come in on the first day, and it's adjourned for about 8 weeks, in between those 2 dates, the statements should be sent to your solicitor in that time. So the first thing you do is to find out, have they been charged. If they have, then you got to get court organised straight away. It does amaze me when people come in, and it doesn't happen too often, people will come into court without a lawyer for that, for drink driving. The consequences of being convicted for drink driving is a disqualification, and the knock-on effects of that are, everybody knows. It could affect your job, your ability to earn, your mortgage, everything. It's huge. And if a person comes into court, every judge I've ever seen will always advise that person that they should get legal advice, because the consequences are severe, and they don't want to be imposing any penalties on a person unless they've been properly advised. So yeah, you should, certainly, at least speak to a lawyer about it.